This is Oscar Extra, the visual version of our pop-up radio channel. We're looking at key aspects of the trial with our experts, people you've heard many times on Oscar Extra, Advocate Mannie Witz and attorneys Tyrone Maseko and Cliffy Alexander. Now, one of the key moments I think we haven't addressed yet is the evidence of the firearms expert, Sean Renz. I remember, Cliffy, when he was giving his evidence, you phoned me immediately and said, this is crucial. Why was this evidence, which I think the media to a large extent missed, why has Sean Renz's evidence been so critical?
David, yes, in a nutshell, Oscar Pistorius wrote his competency certificate so as to obtain more firearms. In that, he indicated that he knew gun laws per se. He knew when he could shoot and when he couldn't shoot. He knew how to store, and he knew when it was illegal to store firearms or ammunition. He could not come later on and say that I didn't know. Excuses, no defence per se, and there's case law about that. He completed that, he passed it with flying colours. In his own handwriting, you'll recall, Harry actually read it out to him. He indicated his knowledge of the act. His actions in this very case are totally contradictory to what is contained therein.
Tyrone, you also feel Sean Renz's evidence has been crucial?
It has. I mean, I think it really basically renders almost impossible, really improbable that Oscar Pistorius could get away with a conviction of culpable homicide at best for him. Because it means, culpable homicide really is looking at whether your actions are reasonable. So to the extent that it can be shown that prior to the incident, you actually understood which actions you couldn't take in particular circumstances, and you still proceed to actually take those actions. As far as I'm concerned, that's it. That's the end of it. Because then you couldn't argue that, well, this and that. Because there it is in black and white that you actually know what not to do in those circumstances.
What other, for you, Mannie, have been turning points in testimony, key moments where you felt this trial is taking on a new perspective?
I think when Merrill Foster gave evidence, I think that took a whole new turn on it, and I mean that led to him being sent for observation for 30 days to Wes-Koppies, luckily as an outpatient and not as an inpatient. And I think that was a key turning point, because if that defence succeeded, and if he could have shown that he did act with sane automatism, and I think Barry's raised that in his heads of argument, he spoke about abused women, etc., etc. I was involved in a lot of those cases, Potgieter, the Ingram case, all of those, temporary, non-pathological incapacity. Doesn't matter what anybody says, if that defence succeeds, you get acquitted. Forget about neighbours, forget about ballistics, forget about everything. So I think that was a key turning point in that particular case, and I think Harry very, very cleverly, when he brought the application to have him sent for observation, negated, not even rebutted, negated that completely, that could never ever be a defence of Oscar's. I think that was a key turning point in the case.
Let's look at some of the other issues. Much was made of the WhatsApp messages. I think there was more of a media interest than anything. Was there a legal significance, Cliffy, Tyrone, to the WhatsApp messages?
What was for me interesting, David, is that I actually thought that those messages were not necessarily incriminating for Oscar Pistorius. I actually thought they were an opportunity for Oscar Pistorius to redeem his credibility. He actually could have considered a lot of those points. I mean, you had messages from River Steenkamp speaking directly to Oscar Pistorius. And Oscar Pistorius' response would be a nonchalant, well, my lady, that was her opinion, I don't agree with it. And I don't think they would have done him any favors. Strictly speaking, if as a matter of law, factually, it might not be all that significant. But given the fact that his credibility had been hampered so much at that point, he actually could have clawed back some of that by simply actually admitting that, look, I did wrong. I'm not perfect. Yes, I may have been bad towards it at times. I could have been a better person. Remember, this person is deceased now.
Cliffy, for you, did the WhatsApps have any significance? I think we got a certain amount of bizarre humour out of the way in which they were read out by the various legal representatives. Was there significance to that?
David, yes, it was a very clever way to smuggle otherwise inadmissible evidence into the record. Character evidence, hearsay evidence that went in. Normally it would be inadmissible. Very cleverly done.
The reenactment of the bathroom door, putting that up in court, was that necessary?
I think it was necessary. It saves you an inspection in loco, and I think it keeps bringing back and hammering home that whoever was behind the door, and unfortunately it was the late Reaver, had nowhere to go. And if one looks at that small confined space, etc., what was the danger to Oscar? And if one looks at the shooting and the entrance and where the bullet holes went, it shows you that whoever fired those shots only had one intention on his mind. Whoever was behind the door, he intended to kill that person. So I think reenacting it, showing it, reminding you every day that it was there in court, I think had a very, very good visual effect. And I think the state were clever to do that.
I think possibly one of the more shocking moments was when Kelly Nell put the photograph of the dead Reaver in front of Oscar Pistorius and told him to say, I killed Reaver. That really had the courtroom gasping, though, Cliffy, you anticipated that that would be the tactic.
David, yes, indeed. You'll recall that. I think that we actually took a bet, the two of us.
How he would start.
Yes, indeed.
And you
it
said,
was actually stated,
show the photograph.
The first couple of questions he's going to show a photograph. And that's exactly what it did. And for him, it worked. Barry's tried to negate it in his heads of argument. It was shocking, as Mannie's already correctly pointed out. I think Reaver's mum and family members were warned about it, but it got the desired effect, no doubt about it. Oscar was too comfortable in his environment. He got him out of the comfort zone.
Is that the tactic as a cross-examiner, to take the witness out of their comfort zone right at the start, Tyrone?
Well, I mean, there are different ways that one can achieve the intended purpose. That's certainly one way, and it really does depend on the witness that you're dealing with. You know, with some witnesses, one could give them an impression that you're not attacking them. You could ask questions in a mild way. In fact, ask questions that sort of beg it, because this is cross-examination, that beg a yes or a no answer, knowing very well that, now that you've got their trust, they're simply going to agree to everything that you're saying, completely unawares of the concessions that they're making. That's one way of doing it. The alternative way is exactly that. I mean, when you've got a witness who's been prepped, as well as Oscar Pistorius, well, we assumed he would be, then you might want to dismantle and get them off that high horse very quickly. So different strokes for different folks.
Mannie, final word from you?
Final word. If he was running a race and he was trying to get into a good position, he really got knocked out of his stride. That was the end of his race. That's what happened to him.
My thanks to our experts, Mannie Witz, Tyrone Maseko and Cliffy Alexander. And don't forget, full coverage of judgment in the Oscar Pistorius trial on Oscar Extra at 9 o'clock in the morning.